Very good morning to all who are joining us today. This webinar is organized by the International Federation of Journalists, IFJ Asia Pacific, in collaboration with the National Union of Journalists Malaysia, NUJM. Hello, I'm Norman Goh, journalist and producer of weekly podcast Bicara Minggu Ini, covering current affairs, politics, and socio-economic stories. Hundreds of editors, journalists, and media staff were laid off and rendered unemployed as a result of challenges faced by the media industry to stay afloat. So the COVID-19 pandemic came as a double whammy, forcing several media companies to shut down and downsize to keep themselves afloat. In this webinar forum, we will be speaking to key experts to understand how existing laws and regulations impact media personnel's news gathering activities and social media posts during the pandemic. I think we've also seen some of our journalists getting called for investigation, some forms of intimidation, even some challenges in reporting in the midst of COVID-19. So to start our conversation today, I would like to invite Norila Daud. She is the Senior Vice President of Asian Journalists Association, AJA, and former NUJM President, to say a few words. Over to you, Norila.
Very good morning to everybody here. As what Norman said, that I was formerly the NUJ president for 12 years. And during my time, the union was a very effective body in protecting the rights and the rights bowl of journalists because all the newspaper companies, the journalists working with the newspaper companies are relatively members of the National Union of Journalists. So we were at that time about 1,200 members. But as time goes by and the political landscape changes in the country, the media industry and also the internet revolution coming in, the online journalism, has made the newspaper industry smaller and smaller and just like phasing out from the media industry. So as I could say, the journalist landscape or journalism landscape is very much different compared to 10 years and today. So as you see now, the topic is the legal and the professional rights of employment rights of journalists. As you can see that many of the newspaper company has exercised layoff, retrenchments, and VSS, voluntary separation scheme, and also the mutual separation scheme. That all the goal is to downsize the media forces in the industry. So even though we have all the rights, we have the legal rights, the employment rights, and the professional rights, but at the end of the day, the crucial point is the company's affordability to pay journalists. If they have not enough finance to maintain the journalists, so what alternative do they have? So you can see today many journalists are out of job. As I can read it out here, Utusan was the first to lay off about 300 journalists in October 2019. This is very early part of the change of the Barisan Nasional to Pakatan Harapan. And in December, NS National News Straits Time have exercised retrenchment where we have lost 190 members. And in June 2020, they also had a retrenchment. This more to the media prima, including the TV stations. And also the Star, which is quite a very strong financial media company, has also exercised MSS and in 217, and VSS in 216, and another MSS in November 2020, where with all these layoff retrenchment exercises, we have only 480 members today. So there is about 1/3 of the total numbers that we had in 2018 before the election that the Barisan Nasional had lost. So this is the landscape or the newspaper industry landscape in Malaysia today. I think this is not only exclusive for Malaysia, it happens all over the world as the media industry, especially the newspaper industry, is phasing out and going to the age. As we know, National Union of Journalists is the only trade union organization that protects the benefits of the journalists and also the press freedom for journalists. And other associations, they only focus on the press freedom, but not for the rice bowl of journalists. So we are very much working on in line with the Employment Act 1955 and also the Trade Union Act 1959, where the Act regulates and registers the constitution of trade unions and the rights and liabilities of trade unions. So under this Act, uh, all the branches of the NUJ has their own collective agreements. Under this collective agreement, we have all the rights, including the workers' wages, the overtime, the benefits, the a little bit of legal rights protected by the company, and also the gratuity and the long-term benefits of the working journalists. So we are also very strong with aligned with IFJ because as you know, Malaysia during my time was very much under the threat of Internal Security Act, Official Security Act, and all the draconian laws that are always behind us, you know, behind journalists. Because when the Internal Security Act was a very powerful tool to stop anybody from voicing out their minds and their dissatisfaction. So and also the journalists were the ones who will relay the message to masses, and we are also part of the ICA. So the ICA is a very strong tools to um, delay or to stop the journalists from really expressing their freedom through the newspaper or any media that they are working for. So now that the IC is not around, and the Facebook and the other platforms, you see the journalists are becoming more freer and more courageous to write their minds. But to bear in mind, some of them had also been questioned and also been charged in the court. So whatever platform or medium that journalists are working, they are not what call that, they do not or they don't escape from all the laws governing the freedom of the press or the freedom of expression. I'm not saying that there's no freedom of expression at all in Malaysia today. They are increasing or the rate is better as compared last time, but still we have to bear in mind there are still laws that we couldn't go easily or escape from it. So that's much I can say. And another point is that being affiliated to IFJ, we have a bigger spectrum to voice our minds and to express our mind, because they are there to support us in Malaysia during my time. So I still remember when we had one journalist detained under Internal Security Act, and we told the authorities that if this journalist is still under detention, we will not hesitate to message this to IFJ to tell the world that we have ISA and a journalist has been detained. So that is about all at the moment. Thank you very much.
Thank you so much, Pak Norila. And to begin, and some of the few things that Madam Norila has shared kind of reminded me of what's happening around the world as well. And looking in Ethiopia, where a journalist, a cameraman from Reuters was arrested and detained for covering the political situations in Ethiopia. However, in Malaysia, although situation has improved, we still have some of these restrictive laws and draconian laws still in place. We still haven't seen the media council to properly establish, still in the pro tem. And I think looks like a long road ahead. So to begin, let me introduce you to our speakers today. First one, we have Andrew Koo. So Andrew was called to the Bar of England and Wales by the Honourable Society of Grace in 1991 and admitted as an advocate and solicitor of the High Court of Malaya in 1995. He currently serves as co-chairperson of the Constitutional Law Committee and is a member of the following Bar Council committees, namely Human Rights Committee, Legal Profession, Migrant, Refugees and Immigration Affairs, Child Rights, Orang Asli Rights, Reform to the Legal Sector, and Task Force of IPCMC. He was a member of Bar Council Institutional and Law Reform Committee and Islamic Finance Committee. Andrew has served as a co-chairperson of the Human Rights Committee from March 2009 to April 2019, and ad hoc committee of AMLA from June 2011 to April 2019. Andrew has represented the Malaysian Bar in giving training, seminars, public briefings, public forums, press conferences, and print and media interviews, speaking on wide spectrum of human rights issues in Malaysia. He has drafted and edited the Malaysian Bar submissions to the United Nations Human Rights Council in Geneva in respect with the Universal Periodic Review of Malaysia in 2008, 2013, and 2018. He has also written over 70 articles published in local and foreign news outlets, including Malaysia Kini, New News, Straits Times, and the Wall Street Journal. Secondly, we have Mohan Ramakrishnan. He was called to the Malaysian Bar in the year 2000 and has been in active practice since. He mainly handles the industrial relations and labor cases. As a seasoned industrial relations litigator, he has handled various disputes, including but not limited to a wide range of matters relating to dismissals from employment, including constructive dismissal, collective agreements, trade disputes, etc. He's also an active speaker at seminars and forums on industrial relations jurisprudence. Prior to practicing law, Mohan was also one of the top 5 insurance companies in Malaysia then, in charge of Maritime and Aviation Insurance Claims Department for a period of 3 years. He was also an accredited maritime insurance trainer in a collaboration between Mitsui and PIAM. At present, he practices law at Mrs. Ramakrishnan and Associates in Petaling Jaya. So I welcome Andrew and Mohan to the webinar today. So coming to the first part of our discussion, I'll bring this to Andrew for a start. When it comes to, these days we are facing a lot of misinformation and disinformation. I mean, a lot of readers out there, a lot of consumers, people out there are really confused between what's really real, and what's fake. And does it actually open up to a lot of opportunities to the authorities to tighten up the freedom of expression? At one time, there were talks about bringing back the anti-fake news law. So Andrew, there were nearly 300 investigation papers on cases related to fake news on COVID-19 pandemic. They were open this year. Only about 10% of them were charged in the court. So as I mentioned earlier, despite the repeal of the Anti-Fake News Act last year, we're seeing a growing trend of the spread of misinformation and disinformation in Malaysia. Can you weigh in your thoughts about it, Andrew?
Norman, hi. Thank you very much and good morning to everyone. And thanks to IFJ for inviting me to be a part of this webinar this morning. To answer your question, I think we have to just like an onion, we have to peel off several layers. The first is, I think, the fact that at the end of the day, the responsibility for news and for spreading news does lie with the consumer, the reader, and I think it really is important for people to check the facts first before spreading or sharing news. I think that's the first thing that I think I would like to get across. People seem to be in a race to want to share news, but they don't check first. And it's with modern technology now, it doesn't take very long to check the facts of any particular news story before sharing it. So I'm a bit surprised when people say, "Oh, I didn't check. I just," the usual phrase, "well, forward as received," and to me that's like rubbish. Basically, you should check. The second point I think we also want to raise is the fact that news is very dynamic. So what exactly is misinformation or disinformation? Let me focus a bit about misinformation. I mean, misinformation at the end of the day could merely be errors. So you go to a story and the story says, accident happened, 4 people were injured. Well, that may be true at the point in time when the report was made, but later on, it's realized or it's discovered that 6 people were injured. Now, is that misinformation? Is that disinformation? Or is that just, the story develops as, new facts are brought to light? So I think this is also something that should be taken into account, especially by the authorities, not to be so strict in the sense of saying like, oh, you said something that was not true. Well, it may have been correct at the time. It may no longer be correct. So give you an example in this sense of, in this period of COVID-19. You remember, Norman, I think, when it first started, there was, talk that we should not use face masks. And really the reason for that, if you go back to the story, was that there were insufficient supply of face masks. So members of the public were asked not to use face masks, not because face masks were wrong, but because face mask supply was limited, and the priority should be given to frontliners and things like that. And then, of course, later on, as supplies developed, people were then encouraged to use face masks. So if you look back at the story and you don't know the facts of the contemporary situation, will you say that, it was fake news to say that, you should not use masks? No, again, it's a question of the story developing and the facts changing. And as the facts change and more facts come to light, the story will change. So I think there's a certain element of, as I said, dynamism in these issues that need to be taken into account. And then thirdly, just for now, we can continue this discussion. Thirdly, I think you have to distinguish between opinion versus fact. Some people are spreading stories. Some people share stories. But are these facts or are these just expressions of opinion of people? And then, of course, the question is, what is that opinion based on? So people need to distinguish between what is an opinion, a view, versus what is a fact. As as also has been said, you are entitled to your own opinion. You're not entitled to your own fact. So I think these are some of the things that we need to understand when it comes to fake news. And then finally, of course, just to say that, when the fake news legislation was being introduced in Parliament, the Bar Council, of which I was a member then, I'm not a member now, we said, and we still maintain, I think, that there was no need for specific legislation on fake news because we already have sufficient legislation that deals with false news. And so, we can deal with issues regarding false news using existing legislation. So, I'm glad that the Anti-Fake News Act has been repealed, and there's, to me, no reason to bring it back because we have sufficient laws at the moment to deal with any situation of chronic misinformation and disinformation. So I leave it there for the time being.
So in your opinion, Andrew, what is the current situation that we have in Malaysia? Are we doing enough to curb this problem? I mean, even journalists, they themselves became the center of attention. Even they themselves caught in a trap, even in middle of all this with the spread of information, and then themselves get caught in the middle. And then at the end of the day, newsrooms will have to retract the stories. So, looking at this to follow up though, despite all these efforts to educate the public about media literacy, and then teaching them about, and the authorities are using existing laws to curb the spread of falsehoods. How different are we compared to Singapore? Singapore has POFMA, the Prevention of Falsehoods. And now it's even more pressing. There's still a lot of misinformation about vaccination. Just now, as I mentioned, journalists are falling prey to the situation, and they're exposed to these sort of challenges. So do you think the authorities today are using this as a blanket way to restrict freedom of expression?
Well, I think your question, needs to be understood in a bigger context. And really, to me, the main issue is the availability of information. And I think what is the problem in Malaysia, generally speaking, is a lack of sufficient information. So right now, what we have, of course, is daily briefings, daily press conferences, where the government puts out a particular perspective, and of course, journalists will then go and they will report that. But again, based on what I said, there are facts and there are opinions, and the question is, you have to distinguish between the two. And sometimes when press conferences are being made, again, you have to distinguish between what is the fact and then what is an opinion based on those facts. So of course, different people can come to a set of facts and come away with different opinions. So to me, again, if it's honest, if it's done in all sincerity, I think there is the possibility of course, there being differing views about the efficacy of vaccines, for example. I mean, there is one line that's been put out by governments and pharmaceutical companies about the efficacy of vaccines and lack of adverse side effects. But then there are other views based on other scientific studies that basically come to the conclusion that, well, it's not so clear cut. So as long as this is being done in the with the sincerity or with the honesty of trying to promote or to convey information about different perspectives, I think that should be allowed, and that is part and parcel of the idea of freedom of expression, which is not just the freedom to express your own opinion, but also the freedom to receive information, to disseminate information. So I think the authorities should, resorting to the law to punish people or to threaten people, I think is the last resort. The thing that authorities should be doing, and to a certain extent they are, is to put out their information, to counter what they think is wrong information, with facts, so that people can decide for for themselves, rather than just say that, oh, I don't agree with you, I think you are wrong, and I'm going to try and find a way in law to shut you down or shut you up. I think that's the wrong approach. You curtail false information or wrong information by arguing the facts and putting out the facts to support your case. I think that's a way a more mature society would deal with issues like this.
Yes, Andrew. I think we've also seen quite a lot of discussions and also exchange of angry comments because I think generally Malaysians are still not that mature enough having differing opinions. So Mohan, I'd just like to pick your brain on this. What's your take though?
Okay, to me, see, the thing is, as Andrew has rightly pointed out, he says, there are facts, there are opinions. So at the end of the day, if a journalist wishes to report on something, go back to the source. I think that is the most important thing. You go back to the source, you investigate, you research on that issue before you put it up in your article. Now, the journalists need to know that they need to be more responsible in reporting. Now, when you say more responsible in reporting, what I mean is speak to industry experts, all right? That will give you a justification to come up with that article. So it is very important that you research, go to the right people, do not just take opinions of people on Facebook or any other social media and take that as the gospel truth and put it up, because that is not going to get you anywhere. You will have problem with the authorities if that is going to be false information. You see, so the only thing you need to do is make sure your research is done, you investigate properly, go to the right authority, the right people, right experts, get their opinion. If you can justify your article, the authorities can't do much to you.
Thanks, Mohan. Moving on to, from our earlier brief discussions when we were before we started the webinar, there's always the pinching point of our work as journalists is that how do we access the right information? Just now, Andrew has rightly pointed out is that whether from news press conferences, the press getting access to this of information, and then sometimes when we do investigative stories, how are we going to protect our sources? So Andrew, it is extremely difficult these days to access more information in the midst of the pandemic. It can be about COVID-19 or it can be about corruption or whatnot. So with a blanket restriction after the change of government this year, nevertheless, the government provided the daily updates through press conferences, but not everyone can attend. Still some of them, but there are still a lot of restrictions imposed. So it's often that newsrooms and journalists publish stories quoting insider sources that may negatively impact the government of the day. So are newsroom protected with the right not to divulge sources of information for the stories? Or can they protect their sources?
The short answer to your question, Norman, is no. There is no specific protection in Malaysian law to shield journalists from having to reveal their sources. So I use the term shield law. So you get shield laws in other jurisdictions in America, for example, in Australia, and to a certain extent in say Canada or the UK, where there is the right not to reveal your sources. But even in these jurisdictions in the past, before laws were introduced, shield laws were introduced, then journalists had to basically put their integrity and their reputation on the line. They might be harassed by authorities during an investigation stage to disclose their sources. And then if they remain silent, they could be prosecuted for obstructing investigations or things like that. And then it would have to go to court. And sometimes these journalists ended up in jail, sadly, but the fact is that they did, and some would go in for a few days, a few weeks, or a few months, depending on the severity. But the courts, even in those circumstances, had to balance, the right of the authorities to investigate versus the right of the public to know. And so in that sense, the judiciary had to play that very crucial sort of like refereeing role to say we're going to punish, but we're not going to excessively punish, because we do recognize the need for journalists to do that job. This issue has not come up in the courts in Malaysia as far as I can recollect. A lot of the times it is at the investigation stage where journalists are perhaps pressured, or they are in the cut and thrust of investigation, they the pressure is put on them to disclose their sources. But I think at the end of the day, it's a question of up to the journalist to decide whether or not this is something that is important enough for him or for her to stand up and to face the consequences.
On that note, from Andrew, I'd like to bring this to Madam Norila, as a former NUJ president. In your line of your work for decades, when it comes to protecting our sources, because this is also our the professional code of conduct as well, as we have the right to protect. Unfortunately, we don't have, we can't protect our sources in this way. Do you think, in your opinion though, do you think that there is a need do we need to push for a law to make sure that we are allowed to publish stories where if it is of a public interest?
I think it's high time for the media practitioners or the stakeholders to fight for the rights to be protected, because now we are in the very challenging world, because we have information going everywhere, coming from all kinds of sources, So some sources are against and some sources are supporting, but journalists, we don't really know where or who to quote, because there are many sources and sometimes it's so professionally done and professionally voiced out, but that doesn't mean that the information are all correct and useful for the public consumption. So I think high time for the Malaysian stakeholders and the media practitioners to fight for to protect journalists for their sources of news. And one good point is that we in Malaysia, we are binded by the Code of Ethics, journalism Code of Ethics or Code of Conduct. As you know, the journalists, the proper journalists or proper professional journalists, if they work in a newspaper company or any media company, they have the gatekeepers. So I think the chances to have the sources wrongly quote or to deviate the information from the truth is a very small chance, because the gatekeepers will be responsible for the end results of the write-up or the features. So the most problems is with the netizens who writes anything they like on the Facebook or whatever platform, and they are the most likely to quote all kinds of information that make the public confused. But professional journalists working in the proper media industry or media company will not do that, because they have all the gatekeepers to check on the sources and the all the laws that will be behind them if they quote wrongly or whatever. So I think it is high time for journalists to have the right to protect their sources, because this is the only difference that make them from the netizens who write outside there without professional background. Yeah.
Thank you,
Norman,
Norila. Yeah,
Norman,
I'll
can
bring
I
it back
just
to you.
jump in?
Sure.
Can I just jump in here? I think Norilla has raised two very important points. She talked about stakeholders. Of course, one of the stakeholders in this scenario are the lawmakers themselves. And I think what is needed going forward is for laws to be passed to actually provide for protection of sources. So we need our own set of shield laws to underline situations in which the protection of sources will be respected in law. That you also mentioned public interest. So there are times when disclosure is in the public interest. It may be a violation of governmental rules, regulations, or even laws, but there should also be a recognition of public interest exceptions, and these also need to be put in law. So that's the first thing. The second thing is, of course, again, when you talk about gatekeepers, I'm not so much looking at gatekeepers, but professional standards. So journalists are professionals, and they should be accountable to a professional body. So whether it's the union or whether, as some people have talked about for many years now, a media council or a press council, there should be a degree of self-regulation within the profession. And the government should should give way to self-regulation rather than to immediately jump and resort to the use of the law. So for example, if there is a complaint, then the complaint about a particular journalist or particular story should be, at first instance, be directed to this kind of media council for them to look at it and for them to decide whether the journalist behaved properly, whether the story was correct, and then to order maybe a retraction, correction, apology even, if the story is wrong. So again, I think the lawmakers really need to speed up the establishment of a independent media council that will be the place, the go-to place for netizens, for whomever, consumers of journalism, to be able to complain if there is, including the government. The government should also go and complain to the media council if they think that a particular story is unfair or is unethical or unprofessional. So I think that's where we need to be going. I know there have been some efforts to establish one. There's been some draft laws that have been proposed under the previous government, and even until under this one. But progress seems to be very slow.
On some of the situations that we face currently, like for example, we see newsrooms getting dragged to the courts over comments made by readers on their website. So when the comments are offensive, who's going to be responsible in this kind of case? So what if the comment is used as a plug-in from a social media platform? Because you see a lot of digital news, they're using plugins from social media platforms. Are they still liable for offensive comments like that? So what if the offensive comment is made on the publisher's social media pages?
Well, I think this involves a whole separate set of issues that need to be looked at. And the question is what they call intermediaries, right? Media intermediaries, and the extent to which they police the comments, they intervene in the comments, edit the comments, or are they just intermediaries that don't do anything and just allow a sort of like a flow through of information? So if you look at internationally, the argument is to basically say that if you are this kind of intermediary where you don't get involved in the editing of comments, then you should not be held liable for things that are put up. So as you say, things like comments on your web page, website, whatever it is, which is not moderated, plugins, that sort of thing, which is not within your control, you should not be held responsible for that. Of course, there will be people who disagree, and that's where the debate is. But then the other thing, of course, is that if you do actually moderate, if you do actually edit, then of course, if you edit and you edit incorrectly or insufficiently and things do get out, then the question is, should you then be held responsible for your failure in that sense to properly monitor and regulate? Of course, that leads to another point as whether or not intermediaries should be under a legal duty or to actually proactively monitor comments. And I would venture to suggest that in this day and age where comments are fast, comments are so many at times, it may not be practical, and it may not be suitable for to make demands on intermediaries to proactively monitor the comments. I mean, to a certain extent, this is again another expression of freedom of speech or freedom of expression, and the people who post are the ones that ought to be responsible for the comments that they make.
Andrew, when you see there are so many different organizations of newsrooms in Malaysia itself. They adopt various house styles, ways of publishing stories before finalizing the end product, whether on print, on radio, on TV, and online. So there's a flow of how news is being processed or late towards the end product of it. So editing of stories by news editors and based on organizational policy, how does this impact the final output and who is responsible for the published news?
Well, that's a very interesting question, Norman. And, thank you again for that very kind intro. I've been interviewed several times by the press, and I've been, in inverted commas, a victim of this kind of editing. So there was I won't name the publication, but there was a story that appeared a few months ago, which quoted me as saying that, I had said that, for the Batu Sapi by-election, that Warisan should just be allowed to appoint a person to take the place of the late Datuk V.K. Liu. So when I read that story, I was a bit alarmed because I never said that. What I actually said was that there should be a no contest and that the by-election should take place and the Warisan candidate should be allowed to win unopposed. That was what I said. So I actually managed to contact the journalist whose name appeared in the byline of that article. And I was surprised, and he was very surprised as well. He said, I never wrote that. So I said, but if you didn't write it, how is it in your article? And then it later transpired that it was added by the editors, and the editors had got it wrong. So if I didn't check, if I didn't probe further, I would have just seen the byline, seen the reporter's name, and said, look, you're responsible, and because the article is in your name. Don't come and tell me, oh, internally the editors changed this, that, and the other. To me, as the consumer of the news, that is irrelevant to me because you as a journalist and you as the press company are one. So of course it was resolved relatively amicably. There was a correction, but there was no apology for misquoting me. But if it was something worse and it goes to court and there's a suit for, say, defamation or things like that, then the journalists together with the newspaper editors and the newspaper company would be on the other side of the court case, being sued for defamation. So I think this is where journalists need to look at their stories. I know it's a busy life and you have to write so many stories and you may not actually read what is ultimately published. But at the end of the day, you have to check what the editors have edited in terms of your story. And again, another anecdote is that, they get quotes wrong. So, I would have to call up journalists and look, I never said that. And then, of course, the journalist said, I've looked at my records, you never actually said that. And then it again transpires that, the editors edited things for brevity and for things like that. And then, edited your comment and took it out of context and it comes out totally different. So The question is, yes, ultimately the editors are responsible, but you as a journalist, your name appears there, and you would be prima facie, on the face of it, you would be responsible.
I would like to ask Norila to weigh in as well, because there are also times where we've also seen several situations of editorializing the headlines, where things, now like what Andrew has mentioned, where quotes are sometimes are taken out of context. And then I understand that there are sometimes the limitations of the limit of number of words, especially when it comes to headlines. But sometimes headlines aren't clear. It tells a different kind of story. So in this kind of situation, as mentioned by Andrew, Norila, I'd like to hear what you think about it.
As I mentioned earlier, that the newsroom structure is such that before a story could be published, it goes in several stages: the news editor, the sub-editor, and senior editor, and the chief editor. That only that level, I think, if the story is critical and controversial, so it goes into a very strict vets. But normal story, it will just go 2 or 3 layers, then it will be published. But as what Andrew said, that the story at the end of the day, or what came out in the newspaper the next day, is totally different from what the journalists have written. I myself I was a journalist, and I myself had often argued with the editor who checked my story, because I was the one who interviewed, I was the one who knows the crux of the subject, and he, out of nowhere, he will turn it until the meaning or the true picture is totally out of context. So as I was a unionist, I could stand on what I feel what is correct. But what about others? I don't know. So most stories went astray because of this misquoted, and at the end of the day, early in the morning, the people will call, oh, this is wrong, this is misquoted. And the next day you see in the newspaper will be a correction and sorry or apologize. So this is the scenario actually. But what Andrew have said, that for his case is very kind of very critical situation, because what he mentioned is different from what is written. Maybe it's a backlash to him as a professional lawyer. So I think he has all the right to make correction, and they have also the right to apologize and make the corrected version. So this is usually the case. But nowadays, when online is concerned, it's very fast. They can change. If you don't like the statement, you can ask them to change, and they will change it. But in newspaper, it's printed is quite difficult and slow. And that is the difference between during the days when newspaper was very powerful, and today it has been taken by online. So I think, I don't know the case of Mr. Andrew, whether it's a newspaper or online. Online is very fast, they can change it, but newspaper, only the next day they can change the true version of what you have said. So that is the picture of the journalists in relation with the gatekeepers in the newsroom. Okay.
Thanks, Narila. I think we have one comment from our participants, from Richard particularly. He said that Freedom of Information Act, FOI, should be pursued and passed by the Parliament. Media Council must be established, currently still in a pro tem, to tackle fake news, inaccuracies, government interference, and other issues that may victimize journalists. I've also checked, I remember some of my earlier readings. In UK, they have protection for journalists as well, in the Contempt of Court Act, where provides, under Section 10, it provides the free and democratic, for example, to protect journalist sources and presumes in favor of those journalists wishing to do so. However, in the interest of justice, national security, and prevention of disorder or crime, information has to be disclosed. Maybe Andrew, would you like to weigh in on that?
Yeah, certainly. I mean, international human rights laws, even when they talk about freedom of expression, admit that no freedom is absolute, and you know there are certain situations in which that freedom can be reduced or limited. So certainly national security is one of them. The problem, however, is what constitutes national security. And unfortunately, in Malaysia, the excuse or the reason of national security has been overused far too many times. And sometimes when you look at it, it's not so much national security, but individual protection. It's about political survival, that sort of thing. So those are not national security issues. So in the UK, it's interesting that, you know, Norman, you quote this in the context of contempt of court. So at the end of the day, it's for the judges to decide whether or not, in this case, disclosure of your sources, disclosure of how you got material is at the hands of the judges, and the judges decide having the full facts before them. So again, in Malaysia, you know, we tend to have a practice of basically giving way to the executive. If the executive says, oh, you know, if government says that, oh, this is national security, the courts would say, okay, we're not going to look into it because the government has said it's national security, and we just allow that to take place. So in a robust democracy which recognizes the role of journalists, the role of an independent media to act as a check and balance on the excesses of any government, the courts should be very reserved about giving the executive such freedom to do things as they wish, and they should be more protective of the right of freedom of expression. So that is how I think it should be addressed. Certainly, I agree with Richard that there ought to be a Freedom of Information Act to take over the Official Secrets Act. I think there's still a need for official secrets. We all recognize that certain things are necessary for genuine national security. And so, that has to be taken into account. But the difference between an Official Secret Acts environment and the Freedom of Information environment is that in the latter, in the FOI, then the presumption is everything should be released except in certain circumstances. Then you list the certain circumstances in which the freedom will be curtailed or limited. Whereas at the moment, we live in an OSA environment where everything is secret unless it's officially revealed and allowed to be disclosed. So it's a totally different mindset. It's a 180-degree turnaround, and so I think going forward, that is certainly where we should be going.
Thanks, Andrew. I think we have also another question from Raja Muragaya. He says that even if we misquoted someone and immediately corrected it online, would we be liable to a lawsuit?
It shouldn't be. I mean, if there's a genuine mistake and there is a quick correction, retraction, apology, I think it should be left at that. I don't think it should give you grounds to pursue it any further, because, as I said, things are dynamic. News is dynamic. You may say one thing today, and then later on, as more facts come to the fore, you may change your story, and therefore, the source may be wrong, source may be incorrect, that sort of thing. As long as you have done your homework, as Mohan said earlier, as long as you have attempted to check your facts, you have tried to get corroboration or support for your story, and you acted in a responsible way. I don't think that a mistake which is ultimately retracted or speedily retracted is something that should then be the basis for a lawsuit. So.
Thanks, Andrew. I think we've come to then our next part of our webinar today, right? Will be that I would say this as the three inevitable realities that we face for a couple of years already. One, MSS, VSS, and retrenchment. We've been hearing this over the past few years, over the past 5 years. So to Mohan though, hundreds of media staff and journalists were offered MSS, VSS, and then more recently retrenched from newsrooms due to downsizing exercise. And some of them just have to shut down. This is not new, but is this the best solution to solve the current situation? What are your thoughts, Mohan?
Norman, you see, well, we've got to see what's the reason for the MSS being offered or the VSS that is being offered to staffs. Generally, of course, they offer such on the basis that there's redundancy to the role of those staffs. This, of course, brings you back to the issue of retrenchment. Okay, MSS, VSS are nicer words to be used than retrenchment. Retrenchment, the company just sends you a letter saying, look, you're retrenched. End of story. Whereas VSS and or an MSS is more of a better way of putting things, where in a VSS, the company tells the staffs, look, we're going to undertake this exercise, so put in your names. Put in your names. Now, these are the benefits, or this is going to be the compensation that you're going to get. The compensation will be spelled out. And so they will then avail themselves for the VSS if they are happy. In a VSS, generally, there is no real room for negotiation between the staff who wishes to take the VSS as well as the company. In an MSS, it's different because that's mutual separation scheme. In a mutual separation scheme, what happens is the employer will contact the employee and say, look, we need to part ways. The management has decided that you will be one of those who are going to be involved in this. The employee will have the right to negotiate the compensation itself. The company will offer a certain package, a severance package. It's up to the employee. If the employee wishes to take it, well and good. They will then sign the mutual separation scheme. The contract of employment comes to an end. If the employee is not satisfied with the severance package, then it gives them the room to negotiate. You must understand, company could relent, they could negotiate and come to better terms. Or the company would just say, look, this is all we are offering, take it or leave it. And if the employee does not take it, then the employee faces the risk of being retrenched at a later date. It could be 1 week later, 1 month later, or whatever. Now, again, the reason will be that your position, your role has become redundant. That is why we are offering you this package. We do not need your services anymore. You see, now, you must understand the meaning of retrenchment is discharge of surplus labor by the employer for any reasons whatsoever other than a punishment or other than as punishment. And before such an exercise is undertaken by the employer will need to inform the Labor Department, Jabatan Tenaga Kerja. They will have to inform them 30 days before the exercise is undertaken. We will have to also see what are the reasons for retrenchment, the principles governing retrenchment itself. Okay, this is important because employees will need to know if the exercise itself is one that is bona fide. It is a valid exercise done in good faith, all right? So the burden is on the company to prove that the retrenchment is justified, that this position or this role, we do not need this role anymore, it's a surplus, so we need to lay them off. That is number one, justification. Number two, whether the grounds for retrenchment itself are true. It cannot be fictitious grounds, right? And of course, number three, that there must be no ulterior motive in the selection of the employees. In other words, all right, it must not be done to victimize the employee itself. Okay, so the burden generally falls on the employer to show these. And the common ground or the common reason to undertake retrenchment exercise is that the finances of the company is bad and the company has got no choice but to retrench those staffs. Now, the company better be ready to open their books first to the Labor Department, and subsequently, if the matter goes to court, at the industrial court or the labor court itself. Okay. Now, that said, as you have asked, okay, what are the avenues? Are there avenues that must be first exhausted before the company takes such drastic measures of retrenchment? Okay, companies should reduce working hours. Okay, that should be one. Number two, reduction or freezing of new hirings. You know, it is no point saying that, you know, we're not doing well, so we need to retrench. On the other hand, we are hiring staff. Okay. Three, limit overtime. You know, if you're talking about finances, then you start limiting overtime, work within the certain hours. And if you require extra work, but within certain times. Instead of allowing staff to work 5 hours overtime, tell them to work within 1 or 2 hours, you stop your overtime. Okay. Next, reduction of wages. Now, many questions have actually
I think Mohan has a little bit of a connection problem. Hi, Mohan. Welcome back. A little bit of a connection problem earlier. So I'll go back to you.
Yeah, I'm having connection issues. Can you hear me now?
Yes, I can hear you.
You can hear me. Okay. Norman?
Yes, Mohan, I can hear you.
Okay. All right. Okay, so the next is reduction of wages. Many questions actually came about during MCO and post MCO during CMCO, where employers have actually approached their staffs and say, look, I need to reduce your wages, okay, because the company is not able to support its operations by paying so much of wages. Can we take a 20% reduction, say, supposing? Unions have asked me, employees have asked me this question, whether this is right. You know, we want to take action against the company. But the first thing I tell them is this: look, if the concerns of the company is real, that, you know, company is struggling, be happy that they are not retrenching you, they are not terminating your services. All right, you may need to work with your company. Work with a company in this sense, and not a reduction that is going to be forever. It will be for a certain period of time, say till 31st December, or for 6 months or 9 months until the company's. So it is good to work with the company and say, okay, because you must understand, unilateral reduction of wages, that means the company sends everyone a letter, says, I'm reducing 30%. That is wrong. Company can't do that. Okay, because that is a breach of the contract, the terms of the contract of employment. It has to be bilateral. Employee has to agree. So if the request is reasonable to it. Okay, so reduction of wages is also another avenue that the company should exhaust first. And finally, laying off foreign workers first. I mean, give priority to the local workers. So any foreign workers whose job is not something that is imperative that only they can handle, reduce that. Okay, once you've satisfied all these and you've exhausted these avenues, then the company can decide to let go of first foreign workers. All right, if you have decided to retrench, foreign workers be let off first. And secondly, if possible, follow the LIFO principle, last in, first out. Now, of course, that's only a general principle. As you know, there are exceptions to it where if the senior staff has disciplinary issues or he's less productive than the junior staff, then you can always retrench the senior staff. So this is how it should work. So again, coming back to MSS and VSS, I will say that, speak to the management, all right? If such a thing is offered to you, especially MSS, speak to the management, get the best deal out of it. Because if you don't, then a few months down the road, because they have already eyed you, they know that, this position has to go. So you will still be retrenched. But if you get retrenched by not accepting your MSS or VSS, you may probably just get 3 months salary.
I think we've lost Mohan a little bit for a while there. So, Mohan, are you back?
Hello?
For the time being, I think because Mohan's bandwidth is...
Can you hear me?
Yeah, we can hear you. We can hear you.
Maybe we can just do voice rather than video. It might help.
Norman, can you hear me? No, I don't know what's actually happening. We live in the 21st century, but internet connection is quite crappy. Okay, now can you hear me now, Norman?
Yes, Mohan, go ahead.
Okay, yeah, sorry. Okay, so as I said, take an MSS or a VSS if you have to, but ask the right questions.
Now, following on that, though, some of the companies decided to reduce allowances during MCO, while another print had to shutter. Before MCO, we've seen overnight, the print company had to shut down, making 200 staff unemployed overnight. So in this situation, right, what rights do the media staff has? Or can they receive any forms of compensation, let's say demand for compensation? If not, what can they do? And then I also want to bring in the same question about, for example, in December 2019, July 2020, Media Prima exercised retrenchment exercise twice. And then later on, Media Mulia reopened Utusan Melayu. This one's from Richard. Can that make sense? Instead of doing other cost-cutting measures, like retrenching workers and open a new Utusan Melayu?
Okay. Now, this is a legal issue, of course, which, industrial court. There could have been some ulterior motive where they had known that, they were going to set up a new organization. So retrench all these staffs, pick a handful of them, take them to the new establishment, and the rest we let go. All right. All these in the basis that, they do not have sufficient funds and they need to close down the organization. Okay, there is an element of bad faith in this based on evidence. So these matter ought to be retrenched staff. They should understand this. Yeah, retrenched staff. You could actually go to the Industrial Relations Department, file your representation within 60 days of being retrenched. Okay, from the date of retrenchment, 60 days, and that's mandatory. You miss the 60 days, you are not going to be able to take the matter to the industrial court. Okay, it goes through a process at the Industrial Relations Department and the matter subsequently is referred to the industrial court. At the industrial court, it's adjudication process. You are able to bring in your evidence. The company will have to prove. As I've said, retrenchment, the burden is on the company to prove. So this evidence of, them opening up a new organization itself subsequent to the retrenchment and the closing down will be an issue which the company will have to explain to court. because the courts will want to see whether the dismissal, yeah, the employees will be able to get back wages and compensation.
Thanks, Mohan.
Norman, and
yeah.
Let me just continue. Yeah.
Sure.
Okay. Staffs who are actually laid off, you've got to first see, whether they fall within the terms of the Employment Act itself. Staffs who are earning 2,000 and below, their terms of employment is governed by the Employment Act 1955. Okay, and if they're going to be laid off, then the Employment Termination and Layoff Benefits Regulation of 1980 takes effect, where they are entitled to termination benefits. And the termination benefits are calculated by way of this formula, that if you work less than 2 years, you get 10 days wages for every completed year of service. If you've worked between 2 and 5 years, you get 15 days wages. And if you have worked more than 5 years, you get 20 days wages for every completed year of service. Okay. Of course, to avail this, the staff will have to work not less than 12 continuous months with the organization itself. For staffs who do not fall within the Employment Act, that means your salary is 2,000 and more, then of course, the termination benefits will depend on the terms of your contract of employment. If there is nothing in there, then what you get is at the discretion of the company. Usual practice is 1 month's salary for every completed year of service. Okay, that is what it is. But again, I wish to remind everyone that if you get dismissed, and this is not yeah, this is dismissal. If you are dismissed,
I think we've lost Mohan for quite a bit. So I will, when Mohan was talking about on that part, I would like to ask Norila, what role does NUJ play?
Norman.
Yeah, Mohan, sorry. I'll come back to you a little bit. I'll just go to Norila a bit. Yeah, because just now you were cut off again.
Okay, Norman. Yep. Normally, the union will seek advice from the lawyer. The lawyer is the expert in advising the union of what to do. As what Mohan has elaborated, I think it's the same as what the lawyer is going to advise the union. So I think the union still have a say there. The union still have the binding of the collective agreement. But as what Mr. Mohan have said, that most, like, let's say in the journalist wages, they are earning more than 2,000, most of them, and very small portion are earning less than 2,000. So in normal cases, they only, if they follow strictly to the Employment Act, they only have like 1 month compensation. That's what happening to some of our friends in the company that have already stopped doing business, and they are in the limbo now, whether to still go to court, where they have a very small chance to win the case, or whether they have to wait for the company to get the money that they should pay them for compensation, because these people are the ones who stay back and not taking the VSS or the MSS, because the company has given them a little assurance of the company's stability and going on with the business. So it's very unfair if they were being laid off and without getting any compensation. As what you have said, the Employment Act will only allocate 1 month pay because their pay is above 2,000. So that is the limbo now.
Yeah.
We don't really know where are they heading to.
It's unfortunate one.
Yes.
It's unfortunate, but as I said, you probably need to go to the industrial relations department and lodge your representation. You're only going to get justice there. You're not going to be able to get justice with a company, because once a company's made its decision, right, to retrench you, and if they are not going to offer you anything more than what has been offered, okay, that is the end of story. Well, still, as I said, retrenchment, once a company retrenches you, the company could probably just pay you in your contract of employment. If your notice period is 1 month, they'll just pay you 1 month's salary in lieu of notice and let you go. You see, so go to the industrial relations department, let the matter escalate to the industrial court and fight your case there. Take your chance there. There is no harm.
Okay. Thank you, Mr. Mohan.
Thanks, Mohan. There's also another issue where I will also pose another question where I've also seen a different kind of situation too. But there are also instances when media companies struggle to pay the media staff, editors and journalists on time, and some result in half-month salary payout over the past few months due to low cash flow. So late payments, unpaid salary. So what rights do media professionals have to demand from the employers?
Okay, late payments, as far as late payments or partial payments that are coming in, okay, media staffs, they could put the company on notice that the company is actually in breach of their contract, the terms of the contract of employment, all right, and give them 5 days or 7 days to pay the balance amount that is due. If the company does not still pay within that time period, the staff could go on constructive dismissal. Basically, it's important to put them on notice. Look, you've reached the contract, the terms of my contract of employment, you've not paid me this much. Now you do have time, 7 days or 5 days or whatever. I will consider myself constructively dismissed. Come the end of the notice period, if the company still doesn't pay, send another letter making reference to the previous letter saying that you have breached the terms of my contract. I therefore consider myself constructively dismissed. Drop the letter. Do not have to wait till 5 p.m. You leave the office immediately. Now that is one option. Again, now coming back, of course, everybody is worried about the livelihoods and the rice bowl. Yeah. So as I've always told clients, as well as people who have actually asked me, work with the company. Work with the company. The company obviously is having issues. If the company has been paying you very well, but these last few months has been a challenge, work with them. Accept what they're giving. Speak to them. Say that this is not enough for me. If you could pay me slightly more, and try working with them first. Because once you go on constructive dismissal, don't forget you do not have a job. Unless you have something waiting for you, you do not have any source of income. And if you do not have source of income, that's going to be a challenge. Yeah. So what I'll suggest is speak to the management. If the management is paying you 50% of your salary and that's not enough to sustain, speak to them and ask them to pay you an additional 20% and say that the balance could be paid when the company is comfortable after a certain period of time. That is the practical approach. But of course, some companies that can be quite arrogant, management that can be quite arrogant. If you know that you're not getting anywhere, give them notice, tell them to make payment. I had one situation recently, the staff was not paid for 5 months, and he came to me, and what happened was the management had actually called him in one day, said, look, I want you to resign. You resign, and they had a stack of cash with them, and told you resign now, I will pay you your 5 months salary. And this guy said, I'm not going to resign. And he came and saw me. And I said, no. And we drafted a letter for him. And he sent him. Within 3 days, the company paid him his salary. But the issue is, I do not know how are they going to treat him from now on. Okay, because he's actually sent them a letter and they will take that as, his attitude. They will not like that attitude, obviously. So I do not know how they're going to be treating him from now on, but well, he's gotten his salary. And I told him if there's going to be any other issues, then we'll have to take them on.
Thanks, Mohan. You know, for this particular part itself, you know, one of the key things is that what about forming a joint consultative committee, a JCC? Is this a viable option for employees to negotiate terms with the employers? Now, I mean, under NUJ, they have different newsrooms. They have their own collective agreement. But we've also seen over the years a stagnation of the salary of a lot of our editors and journalists as well. What's your take on that?
Joint consultative committees, this I think was established in 1970s, if I'm not wrong. Generally, joint consultative committees, the representatives for the workers are appointed by the company, the employers themselves. I've not heard of elections amongst employees to be representatives of the committee. Now, when you know what happens when employers appoint representatives, okay? So unless those representatives can actually go negotiate without fear or favor, that is good. But if they are going to be puppet, they're just going to listen to what the management says and doesn't really, if they don't really, speak for the staffs, then it's not going to get you anywhere. But that said, it is good to have joint consultative committee because the workers' rights, the workers' issues must also be heard, must be put forth to the management. So if the management is going to undertake any drastic measures like reduction of salaries or are going to undertake an exercise of BSS, MSS, then the representatives will be able to go there and talk to the management and try to function. Representatives of the employees must be strong, must be firm with what they are asking. So it is not a bad idea, but as I said, there are no elections of representatives. So whoever they go there, the invitation of the employer itself.
Thank you so much, Mohan, for your thoughts. I think we've come to the final part of our session here. Is that we will move into the question and answer session. I will take some questions from our participants. The first one, I will ask Andrew on this. This one is from Sarah. What if the journalist has already edited the article, but if netizens screenshot the wrong article, who will be liable?
Well, the point is that the correction has already been made. So the question then is, if the netizens themselves are distributing, disseminating the wrong article, then to me, they are the ones that are liable for actually prolonging or promoting the issue rather than the journalists or the media company or the newspaper who's already made the correction. So to me, you can't say, I took a photograph and therefore it's your mistake, but you are the one that's circulating it. So, I think, they should be the ones held responsible.
Thanks, Andrew. There's also another one question from Raja. Is it true that decisions of the tribunal court are always in favor of the retrenched employees? Mohan?
No more. You see, those days, these are just the 80s, 90s, even early 2000s. What used to happen is the industrial court, when matters are even, the industrial court gives the benefit of the doubt to the employees. That said, these days, the courts are very stringent with the application of principles of the law. They will see whether there is any valid reason for the exercise of retrenchment to be undertaken. And if they find that the reasons are valid, they will support the employer. They'll say that the termination itself is with just cause and excuse. So gone are the days where we say that, when you go to the industrial court, it will most of the time favor the employees. It doesn't work that way now.
Thanks, Mohan. I'd like to ask Andrew too, though. When it comes to publishing stories of public interest, Is the existing whistleblower is it? I think is it right to say that a Whistleblower Act doesn't even cover on that?
Well, the way our Whistleblower Protection Act is drafted, you only qualify for protection if you whistleblow to selected authorities. So, as I mentioned earlier, we don't have a public interest exception. So there is no protection for whistleblowing to the press. And I think that's a crucial error or crucial gap in the law, which needs to be rectified. And I think most international commentators, most human rights activists and defenders, when they look at the situation in Malaysia, this is one of their key recommendations, that we do need whistleblower protection in this context. And sometimes you don't want to, or you are, you have reasons why you don't necessarily want to whistleblow to either your internal a control department or a law enforcement agency, because you're not sure that the issue will be properly investigated. I mean, sad to say, sometimes this is one of the concerns, that it will be buried or quashed or just quietly dealt with. So there is, again, especially if it's a major issue, especially in relation to corruption or abuse of power, you want the press to pick it up. But as I said, there's at the moment no protection, and you'd have to, I suppose, rely on the courts to see whether they will give you some form of protection from prosecution.
I remember in the previous, I think sometime one of the discussion among policymakers was about enacting the ombudsman bill to allow, they wanted to improve the Public Complaints Bureau, PCB, change it into Ombudsman Bureau. So we are coming to the end of this webinar. So Andrew, what are your thoughts? What are your final thoughts on this?
Well, I think, first of all, again, thank you very much for having me. I close with probably three thoughts. The first is to recognize the need for a comprehensive relooking at the whole area of freedom of information, freedom of expression, to move to an FOI environment rather than an OSA one, and to allow for journalists to fully play their role as a mechanism to hold government to account, and for the press to be able to speak truth to power. The second is greater responsibility and maturity on the part of consumers of journalism, news readers, readers of news rather, not news readers, readers of news, readers of blogs and things like that, about being able to distinguish between fact and opinion, to check the facts before circulating or forwarding stories, and just generally to be more aware of differences in terms of opinion and fact, and what needs to be checked. The third is for more courage. I want to close on this, and it may take a little while, but let me just try to say it as quickly as I can. A bit more courage on the part of the editors. So I'm not talking so much on the journalists, but on the editors. We talked earlier, Norman, you asked me a question about house styles of media companies and things like that. One of the things that annoys me quite a lot is the different ways in which media companies deal with things that are facts, things that are in the public domain, for fear of being sued. And to me, it's a little bit of an unwarranted fear. So what you will get, for example, you will read, and I'm sure your listeners will will know it. You know, you'll say, oh, a certain Datuk Sri has been arrested. A certain a person with a title of Tan Sri is being investigated. But they don't name the person. And then you ask, why is that person not being named? Oh, well, he's not been charged yet. So because he's not been charged, we have an in-house policy of not naming him. But to me, that is, that doesn't make sense. He is being investigated. It is a fact that he is being investigated. You know that, and so the question is, why don't you report it? Are you saying that you can't report this because you're afraid that you're going to get sued for defamation? But what is the defamation here? Truth is the ultimate defense of defamation. Is he or has he not been detained? Is he or is he not being has been arrested? Is he or is he not being under investigation? Those are facts, right? So you should be able to say without trying to be coyly saying, oh, this Dato or that Tan Sri or this that, name it, right? Because sometimes when you look at it, the same media companies who adopt this practice will have no qualms about naming some Bangladesh or some foreign worker who has been arrested, right? So to me, there's a bit of a discrimination going on, that the rich and the powerful are protected, the weak and the downtrodden are not. And I think we need to get rid of this very class-based approach to reporting. The facts are the facts, and if you report the facts, you can't go wrong. And so I'd ask journalists and ask media companies to look at their in-house policies that have these kinds of very arbitrary distinctions, and that they should review them with a view to getting rid of them. So those are the three things that I'd like to close with. Thanks, Norman.
Thank you, Andrew. I'll go to you, Mohan. What are your final thoughts?
Hey, Norman, before that, Norman, I actually see a question here from Richard asking about Section 6 of the Industrial Relations Act. Very quickly, I'll touch on that before my closing remarks. Yeah? Okay, Richard, Section 6 of the Industrial Relations Act provides for union-related matters for staffs to actually apply for leave. Now, there has been complaints these last few years from certain companies, certain union members that, the employers are deducting their salaries or deducting their annual leave, okay, and not allowing for union leave to be taken. Okay, this has been an issue, of course, but see, what is important is good practice even amongst union members. Okay, it is important that when you apply for your union leave, all right, give sufficient notice to the employer, state particular reason for you to union leave, and state clearly the duration of time that you are actually requesting for that leave. Okay, and employers, as long as it is reasonable, employers must allow. Okay, if they do not allow, then you cannot challenge by way of judicial review as how we have action of the. Can you hear me? I'm so sorry. The connection is so bad.
Yeah, I think it's okay. You can turn on your video, and then probably just because of the low bandwidth, you can turn off your video. You can still speak, no problem. Okay, I've turned off my video. Okay, so now, basically that's it. Yeah, so the company must give you union leave. Now, judicial review is when you are challenging the decision of an authority, government agency, minister. That is when you actually file for judicial review, not here when your employer doesn't give you union leave. Okay, so what you can actually do is you could lodge a complaint with your union. Let the union take it up with MTUC if they have to, and that matter could actually be brought up to your employer. Now, I always tell union, be in good professional relationship with your employer. Things will be easier for you,
when you request for union leave, or when you're going to represent a worker or whatever, your union, your employer will not have any issues giving you your union leave. Yeah. So that's the answer to the question, Richard. Now, my thoughts. You see, we are actually going through uncharted territories, difficult times. Nobody's actually gone through this. Okay, so as employees, it's important that you keep your eyes open. All right, keep your eyes open, see what's actually happening around you at your workplace, as well as within the industry itself. That's very important. And you need to know what's going on in your company. You will need to look at what the management is trying to do with the other departments that may not involve you, but see what the company is actually doing, and take the cue from there. Ask questions. Now, this is important here. You got to keep asking questions to your superior. You got to keep asking questions to your management. If you feel that certain rights of yours are being trampled upon, or if you feel that the management or your superior is being unreasonable towards you, ask questions, ask a lot of questions. Another thing is, learn how to put things in writing. All right, send emails to your superiors. Why? Because you need to have your email trails, or you need to have your communication trails. All right, you just merely ask in person and leave it at that. Tomorrow, if the matter goes up to court for adjudication, you may say that, yes, I've been asking my management, I've been asking my superior. They'll turn around and say, no, he's never asked me anything. You see, so once you have spoken to them, send an email, confirm the conversation on what date, what time, and this is what the management has informed you. Okay, so these are important. Seek proper assistance from lawyers as well as trade union. Okay, don't just go and ask any Tom, Dick, and Harry for advice. Okay, I have seen people coming after getting the wrong advice and taking the wrong steps. At the end of the day, they're not going to succeed in their claim against the company. Okay, so seek assistance. Don't be shy. Pay if you have to pay. It's not going to come to so much, but that's worth it. Yeah, and I'll just touch on these two issues of forced resignation and constructive dismissal. Why? Because forced resignation is also happening now. As I told you, that instance where that guy had actually come to me, and the boss had actually said, you will get your salaries, outstanding salaries, if you resign. Now, forced resignation is prevalent these days. So in relation to forced resignation, you must understand the law is very stringent. The law is very strict on this. Okay, if your management asks you to tender your resignation and say, go and think about it, come back tomorrow and let us know, the law is not going to support you if the next day you come in with your letter. All right, there must be elements of duress. You must remember that. Elements of duress, meaning they tell you, this is the pen, this is the paper, you write now or you're not leaving the room. Okay, so that there is an element of duress, and you have actually tendered your resignation. So the law is very strict. So as far as possible, okay, if you are placed under a situation where you will need to resign, or if you do not have any choice and they're not letting you get out of the room, then put in the resignation, come out, go immediately to a police station and lodge a police report. Immediately, don't wait for a day or two. Lodge a police report that this has happened to me, and take the matter to the Industrial Relations Department. Within 60 days, file a representation. Similar to constructive dismissal. If the company is being unfair towards you, they are not paying you your salaries, and they're not availing you of your rights, then put the company on notice in writing. Give them 3 days, 5 days, or 7 days, or whatever period of time to rectify the breach. Tell them that you have breached my contract, breached the terms of my contract of employment. If you do not rectify this breach, I will consider myself constructively dismissed. Wait for that period of time. At the end of that notice period, if they still do not rectify, you can give in your letter of constructive dismissal, and you can immediately walk out. Okay, so these are important. As I said, the laws become very strict. If you look at the industrial court, cases of forced resignation and constructive dismissal, probably 70% of the cases fail. Okay, so you need to be very careful, get proper advice. That's all I have to say, Norman.
Thank you so much, Mohan.
Thank you, Norman.
Norila, do you have any final words to say?
Okay. Being the former union journalist, what I could say here is, even though journalism, as in the perspective of the industry itself, is going down, but as a journalist, I think the profession should not end there. The profession should go on, even if the newspaper industry is not there anymore, but you can have alternative, going for online journalism, going for other platforms where you can practice journalism in the most professional way, get good sources, and your writing a credible, there's a credibility in your writing, your sources. I think the society will recognize the profession, the journalist profession. And another point is where I want to raise here is about the union leaders. Uh, no doubt we are facing challenges from netizens and people out there who writes like journalists. They claim themselves as journalists, but you being leaders and journalists yourself, you should speak up. You should be more brave and courageous enough to speak up for your rights when the company try to lay off or retrench or offer VSS or MSS, as what Mr. Mohan has already laid the procedures and what should be done. So I think the problem here is the union leaders, that is they are from journalists themselves, should be brave, bold, and courageous to fight their rights, and especially where freedom of the press and freedom of speech. This is the right time you should stand up, because I think with the information going all around, with the blast of the internet, all that, I think there is more press freedom now, expression of uh, individuals, expression through the media, whether it's online or newspaper. I think it's a good test for them. I think never say a journalist is a dying profession. You'll be there as long as you write something good for the nation, developmental journalism, not fake news. You are credible, you are recognized. I think the media will be a powerful tools for nation development and for anything at all for positive uh, objective for the country. So the crux of the problem is the journalists themselves. Who are they? What they want in life? What they want in their career? And where are they heading to? Are they on the right track, or are they only going for fishy issues and that controversial issues that end them in trouble? Or are they just like one of the netizens out there who like to write fake news? I'm sure they are not that kind of people, you know. They are special people with a training background, with ethics, and also with they know a lot of people, and they have a special character, special uh, qualities in them. So I think the crux is the journalists themselves, what they want to make out of themselves, and where they want to place themselves in the media industry. It's, you don't blame the surrounding, don't blame the political landscape, don't blame the platform or whatever. It's just you being a journalist, be yourself, do whatever you should do for the nation building, for the rights of the people, and for humanity, and for the nation building. I think that should be the objective of anybody who wants to be a journalist. Thank you.
Thank you so much, Puan Norila. And that concludes our webinar today. Thank you to all panelists today, Andrew, Mohan, Norila, for your input, suggestions, and recommendations in our IFJ webinar today. So on behalf of the organizer, I would like to thank the Embassy of Switzerland in Malaysia, the European Union, International Federation of Journalists, IFJ Asia Pacific, and National Union of Journalists, NUJM Malaysia. So please join our group on Facebook and continue our discussions and conversations with My Media Matters. That's a Facebook group. So to all our listeners and participants, do follow IFJ's Facebook at facebook.com/IFJ Asia Pacific, and on Twitter and Instagram at IFJ Asia Pacific. We will be sharing this webinar forum on Anchor.fm, Spotify, Apple Podcasts, and Google Podcasts. So have a great week ahead, and thank you so much.
Thank you so much. Bye.